Sorry. Yes, just relax and feel comfortable. If I may say, feel at home also, because this was your home for 10 years. If we could start by asking you to tell us your county and your ethnicity.
Thank you, Honorable CJ. My county is Mandera, and my ethnicity is Somali.
Very well. You know why we ask this very intrusive question?
Yes, Honorable CJ, yes.
Yes, why? Kenyans would like to know why.
It's because of diversity.
Okay, diversity and inclusion and regional balance, which are constitutional imperatives. Very well. Now we'll start. And I want you to tell us who is Justice Warsame, and why do you think you fit this job of Supreme Court judge? When giving us that introduction, we want you to tell us what particular experience you're bringing to this court, skills, knowledge, and we want you to locate that to the jurisdictions that are given to the Supreme Court by the Constitution. If you tell us what experience you have, tell us how it will help you in interpreting and applying the Constitution, in dealing with the matters that come before that court, on general public importance, on advisory opinion, and other jurisdictions. We want you to relate your experience to the work that is going to face you if you are successful as a judge of the Supreme Court.
Thank you, Honorable CJ. My name is, as I stated in my documents, Mohamed Warsame. I'm a judge of appeal. Currently, I'm stationed in Nairobi from 1st of April. What do I bring? I bring over 32 years of legal experience, which I acquired through advocacy, through the judiciary, as a judge of appeal, and as a court of appeal judge. What are the distinct things which I bring, which will help the Supreme Court? CJ, I bring 5 things on the table. The first thing which I bring is jurisprudential leadership. I have been in the judiciary for over 22 years. I have been a jurisprudential leader as a high court judge and as a court of appeal judge. My jurisprudence has gone all over the country, has gone all over the Commonwealth countries, and one of the key requirements of the Supreme Court is the jurisprudential leadership in terms of the judiciary and in terms of the country. It is the Supreme Court that leads the country in the right direction. So what I bring is that jurisprudential leadership to help the court, because I have dealt with all spheres of the law, both criminal, civil, judicial review. I am the first presiding judge of the Judicial Review Division under the current Constitution. So I was the first person to interact with the current Constitution. Secondly, in that area, when the issue of the recruitment and the appointment of the Supreme Court judges came into question, I was the presiding judge who dealt with that issue in the first instance. Secondly, I was appointed to be the presiding judge in a 3-judge bench, which made that landmark decision. Secondly, CJ, what I bring also is institutional leadership. Institutional leadership in terms that I have been a leader in the High Court, in the Court of Appeal, and also a commissioner for 10 years. Leadership of the judiciary is anchored, or is the home of the leadership of the judiciary is the Supreme Court. the Chief Justice is the leader of the judiciary, both administrative and judicial. Secondly, the Supreme Court is also the leader of the judiciary in terms of the leadership, because all the judges of the Supreme Court are members of the judiciary leadership. So what do I bring? I bring the inside-outside perspective of the judiciary, and that will help the court navigate its leadership position as an institution. What that means, I have been a commissioner for 10 years, chairman of the HR for 7 years. I have interacted with the members of the public. I have gone around the country. I know what the Wanjiku needs. What are they expecting from the court? What are they expecting from the judiciary? In essence, what are they expecting from the Supreme Court? They want direction. They want leadership in terms of the resolution of their matters. Therefore, I bring both inside perspective and outside perspective. I know what the Wanjiku needs in terms of how they want the court to lead their affairs. So I bring that on board. The third issue, which is fundamental and which I bring an impeccable record of integrity, which is the hallmark of the leadership of the judiciary and the Supreme Court. We need a court where its record is impeccable in terms of integrity. So I bring that on record, and my record in terms of my integrity is very clear. I have never, in my life as a judge for over 22 years, come into a question where my actions were questioned in terms of my integrity. Therefore, that is a quality which I will bring to the Supreme Court in terms of case resolution. I want, if the issue of corruption is eliminated in the judiciary, that will promote the image and the confidence of Kenyan people in the judiciary. That is one of the pillars, because the Supreme Court sits at the apex. If that issue is led from the Supreme Court, I think the issue of corruption or integrity in terms of this country's expectation will no longer be there. So in order to bring confidence and enhance the confidence of the judiciary and the image of the judiciary, I bring integrity on the table. The fourth issue which I bring is productivity. CJ, I have worked in Kisumu, I have worked in Embu, I have worked in the Milimani Commercial Court, I have worked in the Criminal Division, and I have worked even in the Land Division, and as a JR presiding judge, who was also in charge of the constitutional revision. And one issue which the people of this country want is productivity. They want prompt and efficient resolution of their cases. And that is one issue which I've always put first and foremost in the discharge of my duties as a judge. CJ, I have been, for the last 2 years, I have been the presiding judge of Nakuru. And when I went there, I said, this is how we will work for the people of this country and the people of Nakuru and Eldoret. As a presiding judge of Nakuru, CJ, I was in charge of almost 14 counties. In those 14 counties, there are various disputes. So when I went there, I said to the judges who are working with me, if it is a single judge, we must deliver the ruling on the same day. If it is 5.2b application, we must deliver it within 14 days. And the judgment, we must deliver it in 2 months. We have never failed. For the period of 2 years, I have been there. So that is a pillar. I want to take it to the Supreme Court, such that if that is cascaded to the Court of Appeal, to the High Court, and to the magistracy, we will all be great ambassadors for the people of this country and will improve the image and the confidence of the judiciary. The point is, If the issue of productivity is solved, we will be all good ambassadors of the Chief Justice. So that is an item which I bring. Lastly, and this is also very fundamental, the Supreme Court is a court that addresses the needs of all Kenyans from all parts of this country. There is a lot of burden and responsibility on the shoulders of the Supreme Court. So what do I bring? I bring diversity. I bring the other eye, the other ear, that can listen to the minorities, marginalized communities, wherever they are. And I will bring the perspective of the minorities and the marginalized community and the diversity. And that is one issue which is so fundamental in the discharge of the duties of the Supreme Court. And as a judiciary, if the issue of diversity is resolved, then the image of the judiciary will also be resolved completely. So CJ, with those 5 issues, if given the opportunity,
six
pillars, I will serve with humility, I will serve with distinction and dedication.
Very well. So we are moving on now to another area. So we want you to tell this commission your understanding of the Supreme Court. I believe you have read and prepared for this, but we just want to hear from you. What do you think are the strategic priorities of the Supreme Court, and how can it position itself, like you have said, as a court of excellence?
Thank you, Honorable CJ. The Supreme Court, in my view, is not an ordinary court. The Supreme Court is a special court. It's a special court because that is where the Chief Justice sits as the President of the Supreme Court, and also as the administrative leader of the judiciary. What do people expect from the judiciary, from the Supreme Court, and how can it be a court of excellence? People expect a reasoned, consistent, jurisprudential direction from the Supreme Court. And in that regard, the jurisprudence of the Supreme Court must speak to the people of Kenya. It is not the elegance of how the judgment of the Supreme Court is written. It is not whether it is giving commands or otherwise. What is important to the court is whether it is carrying the people of this country on board. And that can only be achieved if we listen to the people of this country through consultation, through cooperation, and hear the feedback from these people. Secondly, the court also must sit with the Court of Appeal judges, with the High Court judges, and with even magistrates, and find out what are people thinking about this court, because this is our court. And this court has been there for the last 13 or 14 years. It has matured. So it must give jurisprudential direction to the country in all matters. And when the Supreme Court issues a decision, people must be raising their ear. And that's what Kenyans expect. You must carry the Wanjikus on board. Mm-hmm. And that is how the court will earn its legitimacy. And legitimacy doesn't mean delivering excellent judgment. The court must be sensible and must address the needs of the ordinary Kenyans and find out whether the court, for example, is dealing with the right issues in the right way.
Very well. I think we'll go to other areas of examination. I don't know whether you attended our conference on celebration of Supreme Court at 12. That is where we were inviting that kind of introspection.
Yes.
What the Supreme Court has done and the views of academia, other judges. I think that will come out in the course of the interview. Now I hand over to Justice Share to take it from there.
Thank you very much, Honorable Chief Justice. Honorable Warsame, the second day of these interviews, and in the course of these interviews, we've discussed the issue of how decisions coming from the court, emanating from the court, have changed the course of legal history and also impacted on human life. We also looked at some notable jurisprudence that has also emanated from our Supreme Court. For purposes of this afternoon, I want us to focus on one such decision, and you tell us if it has made certain fundamental or settled some very fundamental issues in our lives that we can say that decision has impacted our lives. And this is the case of the BBI. What did the case of BBI at the Supreme Court settle?
Thank you very much, Commissioner. The case of PPI, I think, settled about 5 issues, or 6 or 7 issues. But
maybe you can tell us 5 that you think
yes,
are really important.
Yes. The first issue it settled is the issue of justiciability, ripeness, and mootness of issues that were discussed before the Supreme Court, especially the PPI issues. And in the majority, that issue, they said and discussed and said that the issue of justiciability and mootness did not arise in the circumstances of the case. That is the first issue I remember. Secondly, they also settled the issue of the immunity of the president and Article 143 of the Constitution, and they said the Constitution provides and gives the president immunity against civil and criminal litigations. Of course, I was in a bench myself that made a contrary decision just before the current Constitution, and where we said where there is a direct and gross constitutional violation. For example, if the president one morning dismisses or allegedly dismisses judges of the Supreme Court or judges of the Court of Appeal, he can be sued. That's what we said in the Olekewa case, which happened before in a 3-judge before this court, and it is cited in the Commonwealth, one of the leading cases on the discipline of judges. The other issue which the court settled is the issue of who can start a popular initiative. Under the Constitution, under Article 255, provides 2 scenarios, and one which is an appendage to the first 2, which is that there is the parliamentary initiative and the popular initiative, and then there is the mixture of parliamentary, popular initiative together with parliament. And some of it, the third issue, which is appendage, is the referendum. That issue also was settled. The other issue which was also settled by the Supreme Court is the issue of the quorum of IEBC in terms of receiving and undertaking signatures, and the court said 3 was sufficient. The other issue which was also settled by the Supreme Court is the issue of public participation in terms of the additional 70 constituencies. And the court said there was no public participation. Therefore, that issue cannot be allowed. The other issue, which was also settled by the Supreme Court, is the issue of the basic structure. And they said basic structure does not apply because our constitution is self-executing. There is no provision to say that our constitution does not provide for instances of amendment. The question is rigidity and against flexibility. So that were the issues which were settled by the Supreme Court.
So in other words, what you're telling us is that if we were minded to amend our constitution, the roadmap has clearly been provided by the Supreme Court.
Yes.
And we wouldn't have to falter again.
Yes.
All right.
The only issue which I add,
yes,
with your permission, in such instances, especially a big case like the BPI structure, what I will propose in my view to the Supreme Court, or if I were a Supreme Court judge, we will ask the Chief Justice to write the lead judgment, and maybe the other judges will write a concurring judgment or a dissenting judgment.
Why would you do that?
Because, it is difficult, for example, to read what is the ratio descendi of the PPI in the Court of Appeal, because 5 judges wrote differently, and each one wrote almost more than 100 pages. And in the Supreme Court also similarly like that. So in a very contentious matter like that, for public to understand, because the judgment is not meant only for the lawyers, it's also meant for the members of the public. We should have at least one majority decision, one lead judgment, and then the other judges can either concur or dissent, in my view, for purposes of consistency and for easy location of the ratio descendi of the case.
Judge, does that just apply to the BBI case, or are you saying you're making this recommendation in respect of all other cases as well?
I'm making that in respect of all contentious matters. All contentious matters.
All right.
Yes.
Thank you. Now, let's move to another area. Again, something that we may have alluded to this morning. The doctrine of necessity. When, if at all, did the Supreme Court invoke this doctrine of necessity? And I want to believe that you understand what that means.
Yeah, thank you very much, Commissioner. That is a very difficult area, in my view, of the jurisprudence coming out from the Supreme Court. The jurisdiction on necessity, or the doctrine of necessity, is against the right to fair hearing or the right to recusal by judges. Those are 3 present and coexisting principles. The Supreme Court was called upon to decide on this matter in its early stages in the Rai matter. When it was called to disqualify itself, the court laid very elaborate guidelines in terms of when the court can and should apply the principle of necessity. And the court said, because of the constitutional responsibility of the court, and because of the number, and because of the issues involved, and the efficient administration of justice, the court will not easily disqualify itself or recuse from matters. Again, that is also the position that was taken in the matter of Cholet, where judges who have served or who are members of JSC were allegedly asked to disqualify themselves. And the court also returned back to the issue of Rai and said, the fact that some of the judges, and it's a constitutional duty of the judges to serve in JSC, they should not disqualify themselves because of that administrative responsibility. That is one line which the court has taken. Then there are 2 contrary decisions to Rai and Cholet. One is the issue of Dari, where the court departed from the issue of it said in Rai and Cholet, and now said because of the allegations of impropriety or bias, the principle of necessity will not apply. And then there is also another case, I can't remember, which also addressed the issue of necessity, and which also went by the way, I think, I can't remember, but also the judges refused to disqualify them. Yes, this is the case of Rawal, the retirement age case, which paralyzed the court in terms of the fact that 4 of the judges disqualified themselves from the hearing of the matter. And the judges disqualified themselves because some of them were members of the commission and some of them were affected by the retirement age. Therefore, the judges, the matter was not heard and it was left abeyance. So those are the 4 positions, the 4 cases the Supreme Court was called upon to decide on the issue of the principle of necessity.
All right. I want to give you a scenario.
Yes.
Imagine, for instance, and God forbid, that the Chief Justice, a complaint is filed against the Chief Justice, and the matter comes before the Judicial Service Commission, and the Commission makes a recommendation that a tribunal be appointed. And subsequently, a tribunal is appointed, and the Honorable Chief Justice has to face that tribunal. And you know where, if the Chief Justice is aggrieved by the decision of the tribunal, you know where he or she will file an appeal. What are the dynamics therein that you could say would then encumber this case in terms of, you've talked about the right to a fair hearing, yes? And the challenges that are faced by the fact that, this court has only 7 judges, and hence the invocation of the doctrine of necessity. What do you see as some of the challenges that are likely to be faced? And of course, also given the fact that it would appear that the issue of whether the doctrine of necessity should be invoked seems to be a moving target in that court, with all due respect.
Yes, I don't want to use that word because I know my place in society, but for you, you are a commissioner. That is not a good scenario, first of all. And that is why they should have a dialogue in terms of JSC and the judges of the Superior Court. The question is, a scenario where the Commission is sending its chair to a tribunal is very grave, and very grave in my view. And that scenario, God forbid, should never arise, in my view. But if it ever arises, all judges, and the judges, they have the right to sue in any court. So the Chief Justice can approach the court as an ordinary person who has been affected by that decision, aggrieved by that decision. The Supreme Court judges, of course, we are all human beings, and people who are close to us sometimes may affect our sense of judgment or our sense of reasoning. But there is the oath of office of all judges. So my view would be the judges of the Supreme Court will look at the matter with the correct lenses and look at the law and the evidence and give a correct decision in terms of whether the transgressions accused against the Chief Justice is right or wrong. More importantly, in the decision, some of the decision which went to the Supreme Court, the Supreme Court exonerated a judge and said, no, this matter has not reached the threshold of gross.
I am looking at the question of being a judge in your own cause.
Yes. You see, there are 2 issues. The right to a fair trial The Chief Justice will not, of course, sit in the case. There will be judges, 6 judges who will sit. The quorum of the court is 5. And those 5 judges will hear the matter objectively and arrive at the correct decision in accordance with the Constitution and the law. That's my view.
So if 6 judges were to sit as opposed to 5,
yes,
and there is a tie, what happens?
If there is a tie,
yes,
the Chief Justice will be back.
All right. Right. Finally, from me, you've spoken very, very strongly about corruption, and you've told us about your integrity. And of course, there are concerns about the judiciary and the issue or issues relating to corruption. Indeed, there was a very recent report that painted the judiciary, particularly the magistrates, in very bad light in terms of corruption. The recommendations that you would be making, apart from saying that you want to lead from the top, what other innovations, if I can call it that way, that or recommendations that you would be making in the fight against corruption in the judiciary?
Thank you, Commissioner. I think the issue of corruption or integrity affects all of us. And a dent on one judge or one magistrate is a dent on all of us as judges and magistrates. My recommendation and what I said, that is what we need, an institutional leadership. That is, we need to have a connection between JSC, the Supreme Court, and the judiciary leadership. One thing I will recommend to the Chief Justice and to JSC, all the Supreme Court judges are members of the judiciary leadership team. In my view, I will ask the Chief Justice to send these judges outside Nairobi, maybe every month once, to go and monitor, for example, what is happening in Nakuru, what is happening in Mombasa, what is happening in Garissa, such that the Chief Justice can get correct feedback and the JSC will act. It is not possible for the Chief Justice to supervise every court. When we were few under Gisheru, that issue was very easy because we were less than 40. And we were supposed to file our returns every day with the Office of the Chief Justice. The point is, we must have a connection between the judiciary leadership and JSC. And it is not that every case of corruption should lead to a dismissal of a magistrate or taking a judge to the tribunal. We must have a compromise. And we must put mechanism, first of all, to address these issues before they occur. And one way of doing that is constant inspection. Find out, for example, where the courts are starting at 9 in Nakuru. Why? Because I have seen that report says 59% of Kenyans who went to court were asked of a bribe. Is that the image which we want to portray? Are we good ambassadors of the Chief Justice and the people of Kenya? How can we change? The responsibility is not only on judges or magistrates, it is also on JSC to go outside and find out what is the problem. Why are people involved in this kind of issues?
Thank you. Thank you, Judge. That's all, Honorable Chief Justice.
Commissioner Mwansa.
Well, thank you, Chief Justice. Judge, and you can correct me if I'm wrong, Islamic law stipulates that as a general principle that non-Muslims are not permitted to inherit the estate of a Muslim. Now, this principle was affirmed as long ago as 24th of May 2002 by the Court of Appeal, which was then the Apex Court, in the matter of the estate of Ishmael Juma Chelanga. And recently, the Supreme Court established another principle in the case of FAA versus RFM, that children born out of wedlock are entitled to inherit from their deceased Muslim father's intestate estate. Now, my question is, to what extent has the decision of the court, that is the Supreme Court, created any conflict whether real or apparent, between Islamic inheritance law and the constitutional principle of equality. Secondly, now explain how the principle recently established by the court, that is the Supreme Court, concerning inheritance of children born out of wedlock is to be applied by the Qadhi's courts and other superior courts, considering one, that Islamic law does not constitute a single uniform code of law, and two, that Islamic law is dynamic and adapts to evolving social, political, cultural, and economic conditions.
Thank you, Commissioner. The issues which you have raised are controversial, but simple and straightforward, in my view.
Yes.
Controversial because the way it was put to the public and the way the case was handled makes the matter very controversial. And that's why I said from the start, there is need for the Supreme Court to organically carry every citizen of this country in its decision making, contextually and textually. And that can only be done if the court hears everybody. And it is not possible for the court to hear everybody. What is this principle? Because the biggest misunderstanding which has been created is that Islamic Sharia, properly understood and interpreted, is pluralistic. There are different perspectives. As you know, Commissioner, this matter started before the High Court, and the judge proceeded under the Succession Act initially, but he applied Islamic law. There were 4 issues which were in contestation before the judge. There was the issue of FAA, and the issue of the 2 girls, the 2 ladies who were sisters, the Mawasis, and the issue of the last lady, those 4. First of all, Islamic law, properly understood and interpreted, has basic principles in terms of inheritance. Islamic law of inheritance is principally just benefit, fairness, and justice in terms of its interpretation. And it says, anybody who departs from those principles of fairness, justice, it is not part of the religion. What am I saying? If this matter, look, my biggest concern, I will say first of all, the first thing is, the Supreme Court arrived at a jurisprudentially correct decision. But it has damaged parties who were in that court, in that decision, and the larger Muslim community. And there was a way out under the Islamic Sharia if an opportunity was given to the Qadi. It is not in the place of a party who is seeking inheritance under the Islamic law to question another party. For example, FAA could not question whether the children of the other 2 mothers were born in this way or not born in this way. It's not her place. Islamic law says, if these children were born, how do you resolve these issues? Islamic law on Sharia is based on 2 things, inheritance. It is based on marriage and blood relationship. What they call consanguinity. There is nobody who has contested during the lifetime of the deceased that these children were not his. So the question of whether they were this way or that way, because I don't like the usage of that name, because that is a dent that will follow those children to the rest of their life. If that matter was given to the Qadis, that issue would not have arisen. And they will have come to the same conclusion, The point I'm making is the courts should give an opportunity to the Qadi's court within the sanctioned constitutional boundaries of fairness and in compliance with Article 24(4) that there should be no injustice to the children or to anybody who is entitled to inherit from the estate of the deceased person. My view is the methodology was wrong from the High Court, because if you see the judgment of the judge of the High Court, he ordered for a DNA, which was not applied by any of the parties. The parties were questioning their status. One was questioning, this one is not married. This one was married. Even the appellant, her status in the inheritance was questioned by the other parties, and there was evidence which the judge discounted, rightly or wrongly, I don't know, that she should not inherit. So the question I'm putting is, don't constitutionalize Islamic Sharia, but allow the constitutionalization of Islamic Sharia to function within the parameters of the four corners of the laws on inheritance. That is, they must observe equality, they must observe fairness, and they must not, the decision must not go outside or in violation of the right of the children and the right of the parties who are entitled to inheritance. My view, therefore, is the court reached at the correct decision jurisprudentially, but the methodology was wrong. Islamic law is not an ordinary set of rules or set of cultural rules. You cannot say, for example, Islamic law is repugnant to justice. The culture of, for example, a Muslim who is a Somali or a Kikuyu can be said, his culture, not Islamic Sharia, is repugnant to justice. Because Islamic Sharia provides for all scenarios. And it says any interpretation that results in operation or harm or injury to the parties before court is not part of the religion.
Okay. So just to conclude that discussion on that area.
Yes.
There is a Court of Appeal decision, judge in Otieno, Ogo, and another, I don't know whether you are aware of it, that permitted the derogation from the right of equality and freedom from discrimination on issues of adoption, marriage, divorce, burial, and devolution of property upon the death or other matters of personal law. Now, that derogation was allowed for all communities in Kenya. Now, I want to ask two questions, and I think you've just dealt with it a little bit. Now, to what extent, if any, would Article 24(4) of the Constitution narrow down the possibility of derogation from the right of equality and freedom from discrimination with respect to Muslims? Then number two, what are the conditions to be fulfilled before a person can invoke Islamic law to derogate from or limit the right of equality and freedom from discrimination?
Let me start the last one.
Yes.
Which is easy.
Yes.
And this is my position, and this is the correct position.
Yes.
As has rightly been pointed out by the Supreme Court in that case of Faraj, the Supreme Court, the Constitution is a supreme law of this country. All religions, including Muslim religion, is subject to the tenets and the provision of the Constitution. If any belief or action or issue is in violation or infringement of the Constitution, to the extent under Article 24(4), then it is void. You cannot say, because I am so and so, I want to opt out of the constitutional provisions in terms of equality, in my view.
Okay. Now, I want to go to another area, Judge, the area of elections, and because this is one of the areas that have been highly contested, and largely resolved by the court. But there is a troubling case, the Martha Karua case, that proceeded and went all the way to Arusha, where she claimed that the way she was treated by the court was unfair, and then the court gave some sort of damage. That is the East African Court of Justice. However, before that, just to give context, this case was with respect to an election petition which was filed, and there were many applications that were subsequent in the petition that led to the time that was set by the Constitution to run out. But the time was run out by the court, not by the litigant. So that then we have competing principles of law, of one, that an election ought to be determined, and that has been settled also by the Supreme Court within a certain period of time. Number two is that Martha Karua was also entitled to access to justice and also to a fair hearing. And perhaps I would just want to hear your views about, number one, how would a court, or how is a court supposed to handle that sort of situation, and what would be your also reaction to the criticism by the South African court in terms of how the courts handle that matter?
Thank you very much. I think you are leading me into a minefield, but I have to navigate.
Yes.
First of all, as I stated earlier, it's not in my place as a Court of Appeal sitting here to criticize a decision of the Supreme Court. The decision of the Supreme Court is binding on all judges serving in this country below the Supreme Court, and it is only the Supreme Court that can review its decision, and of course in exceptional circumstances. But let me come to the Martha Karua case. I handled the Martha Karua case one time in the Court of Appeal when the application, her petition was struck out. And the question before the Court of Appeal is, was there justification to strike out her petition in view of the reasons and the grounds set by the applicant who succeeded in striking out? Of course, we had, but let me put one caveat here. The matter stayed in the Court of Appeal registry for 2.5 months without being listed. It also stayed 2.5 months before the trial judge. In terms of election petitions, there are dilemmas which I think the Supreme Court should address. There is the 6-month period which is granted to the High Court, and there is the 6-month period which is granted to the Court of Appeal. There is no timeline granted to the Court of Appeal. I don't know why, or to the Supreme Court, I don't know why. So the question, in my view, which should be addressed, and we took almost ourselves 1 month to resolve the matter. So by the time we were taking back the matter for merit hearing, the 6 months were almost over. So that is the dilemma which I think I will beseech the Supreme Court to address, which is whether the 6-month jurisdiction or timelines is shared between the two courts, whether it is concurrent jurisdiction or whether it is consecutive jurisdiction. Do we, for example, say Martha Karua's case was held in the High Court for 2.5 months. So when it goes back to the High Court for retrial, she has 3.5 months. If her time was, for example, used 2.5 months or 3 months in the Court of Appeal, does she have 3 months if she comes back to the Court of Appeal? Those are the dilemmas which I think should have been addressed by the Court of Appeal in the first instance, and maybe give the Supreme Court an opportunity to address its mind. Another issue which I think is also very important, and which I think has not been addressed correctly, I haven't dealt with that case. Honorable Mother Karua's case was not an ordinary petition. It was brought under Article 22 of the Constitution. And that's how it was framed. It was framed as a violation of her constitutional rights. So the question that comes to my mind, or that we were also struggling with, does a constitutional violation, whether fashioned as an election petition or an injury, has time limit? For example, the Supreme Court said in the Monica Wamwere, the mothers of the political detainees, there is no time limit for such kind of cases. Is it necessary to apply such precedent or reasoning to a petition filed by Mother Karua? I have no answer. But the point I'm making is, here is a situation where the petitioner is helpless and the court is also helpless. So where do you blame? Do you blame legislation? Do you blame the Court of Appeal? Do you blame the Supreme Court judges? I have no answer. But in terms of what the East African Court has said, I think the answer can be found in the advisory opinion by the Honorable AG, where the Supreme Court said its decision cannot be reviewed or cannot be a subject of discussion in another court, whether it is a court below or another court, whether it is East Africa or another court. But that matter has been settled. But the question of concurrent and consecutive jurisdiction in election matters is something live and which must be addressed. And that is the elephant in the room, whether it affects Mother Karua or it affects anybody else. Thank you.
Thank you, CJ. That's all.
Thank you. The Honorable Attorney General.
Good afternoon, Judge.
Good afternoon, Honorable AG.
Yes. Now, correct me if I did not record well, but from your opening statement you said that the Supreme Court must speak to the needs of Kenyans. The Supreme Court must question whether it is carrying the people of this country on board. And then you also said you must carry the Wanjikus on board. Then you again said the Supreme Court must be sensitive in addressing the needs of Kenyans. Again, in answer to Commissioner Mwanza, you said the Supreme Court must carry the citizen. The Supreme Court must carry the citizen in its decision making. I have a very simple question.
Yes.
I ask you this question cognizant of the fact that you and I believe in the supremacy of the Constitution, as you have said. We also know that public expectations matter in a democracy, and that the court must also be sensitive to public aspirations. But we also know that Article 2 declares the Constitution supreme and binds all persons and state organs, and Article 10 identifies national values, while Article 259 directs the manner in which the Constitution is to be construed. Now, from what you had said before and taking into account the provisions of the Constitution, how should the court handle cases where constitutional text, constitutional values, and public expectations appear to point in different directions?
Thank you.
It is analogous to what you are discussing with Commissioner Mwanza.
Thank you, Honorable AG. Public, we know we must understand, and this is the starting point. our constitution was arrived through a rigorous process. It took almost more than 30 years to have a consensus. We could not have a consensus. That is why we had a referendum. And that is why the Reds were defeated. And the Reds were not few people. There were a sizable number of Kenyans. Our constitution, like any other constitution, is a social contract. And a contract, by its nature, has its own pitfalls. There are people who have strong negotiation arguments. So they may agree, or they may have their issues put in the constitution or in the document, while others may have a weaker argument or position. So the constitution is a compromise document. And as C.J. Mutunga said in one of his positions, it has inconsistencies, and it has grammar, and it has many other problems. But it is the starting point. I come to your question. The question is, how do we address? There are two schools of thought. There are judges or scholars who say, no matter your views, we should guard our views, no matter how strong they are, and follow the constitutional text. There is another group which says, look for something that can give rights, the purposive rights of certain group of people who think they did not find what they are entitled to in the Constitution. The point I'm making is, no matter how ardent and strong our views are as judges, we should avoid as much as possible granting or refusing rights which are not found in the Constitution text. Those are my preliminary views.
But do you agree that the courts serve the people by serving the Constitution?
Yes.
And public expectation can be very strong.
Yes.
Where the text of the Constitution is open-ended, it can solve ambiguity.
Yes.
But is there room for amendment of a text, or diluting of rights, or authorization of unconstitutional power by virtue of public expectation and public pressure?
Public expectation or public pressure are not components which can lead to giving a right or denying a right. The starting point and the end point is whether the Constitution provides for the right or whether it prohibits the right. In my view, those are the two criteria. Is the right available under the constitutional text? And then there is something which most judges look at, sometimes even when they are looking for expectation. They say, is it rooted in our history and tradition, so that we can give it some kind of leeway in terms of whether it fits within the constitutional text. But it all depends with the interpretation you want to follow and how you want to regard the particular issue. But everything aside, you know, when you are discussing rights and how to interpret the Constitution, it cannot be in hypothesis. It has to be in terms of contextualize the issues. And it is only when a judge has the correct scenarios or the correct context, he will say, this one is available or this one is not available.
I agree that when a constitution has got historical underpinnings, then
Yes.
public opinion can help in resolving interpretation.
Yes.
But maybe I will leave this for another day, because I'm now trying to reconcile your answer to me and your discussion with Mr. Mwanza about the room for Sharia law and Islamic religion. And I don't think I reconcile the two. Yeah?
Maybe I did not put it as elegant
but
as
we
you
can
want.
do it later on, yeah?
Yes.
Yes. Now, may I just ask you one other question? What should amount to a matter of general public importance for purposes of Supreme Court certification? And I know we've asked this question, we've asked many candidates this question, but I would like to know whether commercial tax or procurement or employment disputes can qualify.
Okay. A matter of general public importance has been defined, I think, consistently by the Supreme Court. In terms of the first case, Hermana's case, and they set down the guidelines. But whether it applies to procurement or commercial disputes, I have no answer. But my answer would be, going forward, I think, in my view, the Supreme Court should leave the issue of commercial disputes, contracts, and procurement issues to the Court of Appeal, such that it concentrates on issues of constitutional interpretation and application. Those are my view.
Thank you, CJ.
Thank you. Justice Murima.
Thank you, Honorable Chief Justice and Judge. Once again, welcome. I will have a discussion with you, Judge, on two areas. And having served as the first presiding judge of Judicial Review Division, let's start with JR. Just to lay the basis for our discussion, just take us through the pre- and post-2010 constitutional legal regimes on JR, just briefly. Thank
you, Judge. The JR pre-2010 was a common law prerogative orders, which only was concerned with the process, the issue of whether the process was right. And you could only issue certain orders in terms of whether the process is right, the issue of Wednesbury, reasonableness on illegality, and the process priority. Those were the guiding principles, and the court could only issue prohibition, mandamus, and the certiorari in the correct circumstances. So it was very restrictive in terms of the fact that under Order 53, there were certain requirements before you could file or succeed. The issue of leave and the issue of the decision must be within 6 months. Those were the position before the 2010 Constitution.
Yes, and post?
And then post, there are three issues which happened post. The constitutionalization of JR in terms of Article 23(3), in terms of the enactment of the Fair Administrative Act, and in terms of Article 47, which provided for Fair Administrative Act, the Constitution. And the last issue is also what I will call commercialization of JR through the CJ's commerce rules, I think, of 2024. Yes.
Are you done?
Yes.
Okay. I hadn't heard about that one, but I'll look at it.
I had not also heard about it myself.
I mean the 2024 CJ Commerce rules.
Okay.
Yes, on operationalization of the Fair Administrative Act.
Okay.
Yes, that's what I call the commercialization of the JR.
Okay. Now with that background, which is correct, I want us to have a look at two issues. the issue of the pleadings. The Supreme Court, through several decisions, including the Dande case, has stated that you can have the remedy or the relief of judicial review either under the Constitution, as you stated, Article 23, or under the Order 53. And if you go under 53, you may be limited to the issue of procedural review if you do not invoke any allegations of constitutional violations or rights violations. But if you go post that and invoke constitutional provisions, the violations of the Constitution and the rights, then you may be, even under Order 53, you may be entitled to a merit review in that matter. That places JR under Order 53, same as JR under Article 23. But how different will be a pleading under Order 53 be from a constitutional petition in Article 23?
Thank you very much, Judge. Under Article 23 and under Article 47 of the Constitution and the Fair Administrative Act and the Common Rules of 2024 have entrenched the JR as a judicial mechanism which is not subject to all the JR of the procedural restrictions of 6 months and leave. The question is whether, under these circumstances, the JR can issue merit review. Under Article 23.3, the orders which can be issued both under JR and under constitutional violations are indicated. And I think there are 4 or 5. But the court has said you can issue appropriate orders under JR and under constitutional violation. The restriction under JR 53, the question is, because of the common rules and the act, does it still subsist? It is still within the statute, Order 53. And I have seen people who have come under Order 53, and because of this, they have not obtained or they did not have the 6 months, their cases was dismissed. And again, I have also seen decisions of the Supreme Court, I think there are 4. The Dande, is it the Dande, which is equivalent to Geller vs. Kasman Brown, which was about propriety rights. The Supreme Court said, of course you can review merit, but under very limited circumstances. And the court enumerated those circumstances. But nonetheless, for example, in the case of Praxidis Namoni against JDC, the company secretary was saying, I did not participate in the tender. But nonetheless, the court said, no. These are issues of merit. Go back. Again, also in the case of Professor Tom Ojienda against the anti-corruption, the court also determined what is administrative and said arrest, search, and surrender of documents does not fall within the purview of an administrative action. So
Judge, just for clarity, am I understanding you to say that when you take the route of Order 53,
yes,
regardless of what you plead, even if you plead all the rights and constitutional violation, as long as you do a pleading under Order 53, it must comply to the requirements of leave and the timelines.
Yes.
That still remains.
Yes.
And is that the case?
Yes.
Under constitutional petitions, under Article 23?
Yes. But usually there is a dilemma. The dilemma is under the Fair Administrative Act, and also under the Common Rules 2024, which are operationalized. The question that arises and which people are asking is whether Order 53 is still necessary.
What's your view on that?
Yes. My view is there is no problem in having Order 53 so long as people are able to comply with the procedural requirement. But I think the most expansive position is, because the court has said there are instances where the court will only review the process, and there's instances where the court will review process and merit. So where do you want to come in?
Okay, now, if you take the view that it may be appropriate for us to maintain both avenues, that is under Order 53 and Article 23, for purposes of treating parties equally, not to appear to be discriminatory to parties. Do you think it's high time the Order 53 ought to be relooked into for purposes of removing the prerequisites of leave and timelines?
I think that is a very good question, Judge. It is not the responsibility of parties, or let me say, it is not the responsibility of the court to say you should be treated equally. It is your responsibility, because you have been given an opportunity to come either within the constitutional provisions. But if you opt under the JR, there is no responsibility on the court to say, because you have come under Order 44, you have been treated unequally against a person who had come under 23 and 47 under the Fair Administrative Actions Act. The opportunity is there. It is the parties to choice. If there is reason to get rid of Order 53, it is not for the judges, it is not for the commission. That is the work of the Honorable Attorney General.
Okay, now let's have a look at the place of merit review in two instances. Merit review before the trial court, and the context here is a criminal trial before maybe a magistracy or any other court, versus either judicial review matter filed in a superior court or a constitutional petition challenging some aspects of that criminal case. So we want to have a look at the place of merit review before the trial court and merit review under JR, whether JR under 53 or under Article 23. And what is usually the challenge is the extent of clarity of these reviews. How different is the merit review before the trial court from the merit review before the JR or constitutional court?
Do you mean the merit trial before the trial court?
Exactly. How different are they? Because they are both merit reviews. How different are they?
The merit review under JR or under constitutional review,
yes,
does not, for example, determine the culpability the innocence or the guiltiness of the accused person. It says whether you have been given, for example, whether you have been given evidence in terms of trial. That's a merit review. And secondly, the merit review under the magistrate is you are testing the veracity, the quality of the evidence that is before court to arrive at the decision whether this person is guilty or not. But the other one, it is not within the purview of the judge who is doing merit review to say this one is wrong or right or is guilty or not.
Okay, so merit review in JR is to the extent of ascertaining whether there are constitutional violations and all that.
Yes.
And merit review of the trial is culpability.
Yes.
Okay. Now, if the JR court or the constitutional court finds for the petitioner, it finds for the petitioner that there are some constitutional violations, will that amount to automatic discontinuation of the trial court, the criminal case before the trial court?
It depends. For example, in the Jirongo case, the Supreme Court said because of the 24 years since the commission of the offense, the possibility of witnesses may have died, that evidence may have been lost. As a result, this man will not get a fair trial in terms of the length of the time. So the court looked at the issue of the process and the issue of the merit in terms of the time which has passed. You see, the court is saying, you have taken 24 years to charge this guy, and there is a civil case which revolves around the same issues. So how will you get evidence in terms of the witnesses and in terms of documentation? Therefore, the court quashed the criminal charges against Jirongo.
Okay, so it does not amount to automatic discourse.
It doesn't, yes.
It's on a case.
On a case-to-case basis.
Case-to-case basis. Now, let's look at structural interdicts. This is a subject which has been litigated on for quite some time, and I think it's now fairly settled. My question is, do you think there is room for structural interdicts in criminal matters?
I don't think there is room for structural interdicts in criminal matters because of three reasons. In a criminal trial, the court becomes functus officio upon conviction and a sentence. Secondly, the decision of the court in a criminal trial is final. The court has no supervisory or residual jurisdiction in criminal matters to issue other orders. Structural interdict by their nature is supervisory, is the court supervising orders it has given. But in criminal, the moment a decision has been given, the court has no place or no position to supervise or to say this should happen or this should not happen. Although the instances where, and you don't know whether it is a structural interdict or not, whether the court retains certain powers in terms of probation. When you have given an order of probation, you still retain a certain limited jurisdiction to supervise the court and find out whether the person is complying with probation conditions. And in the event that he violates the conditions, the court has residual powers to impose a custodial sentence. That is the only instance where the court has supervisory jurisdiction over a criminal matter.
Okay. I think I will leave it at that. Thank you so much.
Thank you, Judge.
Thank you, Commissioner Ngutia.
Good afternoon once again, my Lord. When you're on this other side, when things were hot, you'd ask us to kunywa maji. It's your opportunity to take water. Okay. Judge, I've gone through your sample writings. You did share with us decisions that you've handled at the Court of Appeal on matters touching election petition, matrimonial property, criminal cases, and employment matter. I'm happy that in some of those sample writings, you did share your separate decisions. And I hope if appointed for this position, you will go with this practice, as you had in your opening remarks indicated that it would be good for very contentious matters to have judges write their own opinion. I will highlight two of the matters which I think you have contributed to the growth of jurisprudence. There is the Ferdinand Waititu matter, the petition with regards to his election. In your judgment, you emphasize that not every irregularity warrants nullification, and such irregularities must substantially affect the outcome of the election. So you are able to balance, careful balance electoral integrity, democratic will, evidentiary rigor, and you came up with a good conclusion grounded in law and in fact, and this decision consolidates and refines our electoral jurisprudence, especially on the issue of the threshold of nullification. Then the other matter, which again you shared the decision of the court, is the Pamela Abo versus asset recovery case. The court emphasized that civil forfeiture is, as in REM process, requiring proof on a balance of probability, that property is either proceeds of crime or connected to an offense and not merely unexplained wealth. And ASA must establish the causal link between alleged criminal activity and the fund. So that decision again clarifies the forfeiture law in Kenya, especially the distinction between Pokalma forfeiture and ASECA when it comes to unexplained assets. So I commend you for your support when it comes to the growth of jurisprudence. However, I have a question with one of the submissions you shared, the RESMA, commercial agencies, which at the court of a first instance was a dispute between a wife and a buyer, and the allegations were that the husband had disposed of matrimonial home to a neighbor, and the court had the first instance had actually held that that was matrimonial property. When it came to your court, the majority of the bench, while making reference to decided cases, including those in the UK, you held that, I'm just giving in summary, that marriage or occupation of matrimonial home does not in itself create ownership rights. A spouse must prove direct or indirect contribution on acquisition or improvement of a property. Reading through the decision, my lord, I took note that the wife, though deceased then, had given evidence at trial how she operated a shop in Nyahururu, how she was engaged in farming activities. She cultivated crops, kept livestock, and out of this engagement, the money she got from this enterprise, she was able to improve or invest part of the money into in enhancing the construction of the building and developing the property that was a family residence. And when the husband, her allegations are
that when the husband was unable to meet his obligation as the man of the house, quote unquote, she assumed financial responsibilities, including paying school fees for the children from the proceeds of the commercial activities. In this matter, Judge Professor Ngugi dissented, and his argument focused that courts should also consider the oral evidence and the surrounding circumstances and the real lived realities of informal economies, domestic economies, so that courts are cautioned against focusing so much on strict documentary requirements. And Judge, as you rightly say, courts should look at the plight of Wanjikos, Otienos, and Aminas. The real realities of most women in Kenya is that they don't keep receipts. They are involved in informal economies, in the market, in the supermarkets, or informal workforce. So by you I respectively disagree with your decision that the wife ought to have proven the non-monetary contribution. So the decision, I find it creating a tension between certainty of title and equality within marriage. So this buyer had a title, and you found that he was a buyer for a bona fide purchaser. And how should courts then balance evidentiary certainty? Most women do not have receipts, and the Matrimonial Property Act speaks of the non-monetary contribution. So how should courts balance the evidentiary certainty when it comes to matrimonial property law and the principle or the constitutional requirement on equality? That is one question. And still on that, if appointed as a Supreme Court judge, how would you reconcile again the issue around strict procedural requirements with the constitution transformative mandate to protect matrimonial property and understanding the lived realities of most Kenyan women? Thank you. Sorry it's wrong, but I think you understand the gist.
Thank you, Commissioner. I think that's an excellent question. I look at it from this perspective. In every decision, it is the parties who know the truth. The judge is in the dark. Secondly, in my court and in my career, I have to do justice between the parties. And how do you arrive at justice is looking at the evidence critically and whether a case has been made in respect of a particular proposition. Here is the case was not about matrimonial dispute. It was under Section 17 of the Married Women Act of 1882. There was no divorce between the couple. So what was before court was a declaration that she's entitled to half or 50% of the property. These couples, from the evidence on record, they got married in 1970. At the time of marriage, the lady was working. She had a business. And then thereafter, she was employed. The man was also working. He was working in a garage, but later he was employed in Kenya Post Office. They went to various places. But as they went to various places, there was one constant thing. The lady had her own separate businesses. And the parties acquired properties separately. For example, in the Nyahururu house, or the Nyahururu property, which was 5 acres, that was their original matrimonial home, where they kept everything, the chickens, grow something. So that was the original matrimonial home. It was registered in the name of the lady. After retirement, the man bought a property in Nakuru, which is the subject property. In the middle, he was unable to pay the loan. And they also had separate businesses. There are 3 hotels in Nakuru, in Eldoret. The lady has her own, he had his own. The lady has her own shop, also in Nyahururu. She was selling other businesses. So it is not like an ordinary, informal women who were engaged, who could not account. She had a bank account. For example, when the property in Nyahururu was sold, she banked the 500,000 in her account. And when the man asked for money to offset the loan, the lady did not pay. What happened? What happened is this. This man was sick, from the evidence on record. He was unable to buy medication. His eldest son was also living within the premises. He was threatened by his eldest son, who broke into the main bedroom. There was fracas in the kitchen. This is all evidence. And as a result of his financial position, he decided to sell the property. When he was selling the property, he shared that information with the wife. And this is evidence from when the demand for rent was made. They went to the people, the RESMA people, and asked for time. And the question arose whether they should be given 1 month or whether they should pay 13,500 or something like that. So it is not a question whereby the man sold the property behind the lady. So she knew that this man was selling the property. Again, 1 month after the transfer, and 1 month after requesting to be given more time, the lady filed an injunction. And she got an injunction 1 month later. The case, the man took the position that the lady knew that he was selling the house, he was selling the house, and that they have agreed to build another property in a place called Mwariki, Kiambogo. And that's the man wrote a very comprehensive affidavit when he was sued together with RESMA, and said, all along my wife knew, and I sold this property because I was in financial needs. I could not buy even medicine, and I was sick. And I was buying because my son wanted to burn this house. That is the evidential position. And he says this man is innocent buyer, and we have the money. 8 years later, after the death of the lady, the man now signed another affidavit and said, I have sold the house, but I want my family and my children to inherit it. But I am willing to pay 15,000 shillings per month to refund the money. The case was handled by many judges, including the Honorable Chief Justice at one time. Maybe she doesn't remember. Way forward, it is not a case of where an ordinary lady who could not provide documentary evidence. These are two parties who had separate life, separate properties. And what is the role of the court? The role of the court is to look and stand between the parties. Here is a RESMA who bought this property, but who could not get his money. Even when the judge ordered and said, keep the house, but refund the money. No money was refunded. Even when the matter came on before us for appeal, we asked, what is the position? can you have a settlement? The answer we got is that give us judgment, Resma can sue. And when we ask, they sue who? They sue the person they want. So I fully understand the responsibility of a judge in terms of acquisition and distribution of matrimonial property. And I have dealt with many matters in the Court of Appeal in terms of such kind of dispute. In fact, this matter which we have referred to, which is also a leading decision on matrimonial distribution, was certified by myself and Commissioner to go to the Supreme Court, the JAO matter. The JAO matter, and we raised pertinent issues, whether, for example, Article 45.3 is an automatic 50-50 apportionment. And all these circumstances, and when we have looked at the analysis and the evidence, we have arrived at this man was an innocent purchaser in the circumstances of the case. I am alive to the fact that there are certain documentary evidence in an ordinary rural life which cannot be accounted for, and they may amount to indirect contribution. I have several cases in the Court of Appeal held that this is the way to go. But this is not an ordinary case. This is where parties kept their businesses separate, their property separate, and the lady knew this man sold the property. This is an information correct?
Okay. Thank you, Judge, for that clarification. Though from the reading of of your decision, it appears that was the matrimonial home, and the property that was sold in Nyahururu was supposed to be used to pay off a mortgage, but the husband decided to buy businesses in Eldoret. But I'm happy with when you say that you normally consider non-monetary and monetary contribution. Then which one do you give more weight? Which one would you give more weight when it comes to monetary and non-monetary contribution, when it comes to acquisition of matrimonial property?
You know, my position has always been, this is not about mathematics. It's about the significant and substantial contribution of a lady or a man in terms of acquisition, management, and the division of the property. It is not mathematical, but there must be evidence that one party contributed, whether indirectly or directly, substantially. There are instances, for example, where the lady, as a result of her indirect contribution, gets 70 or 60 or 40%. Look at what we have said in the Rubia case, for example, which I was involved. Look at what we said in the Virginia case, which I was also involved. So it is not a standard to say this is the correct formula. And the problem, in my view, is not the evidentiary. The problem is structural. Why is it structural? The Matrimonial Property Act even was unable to resolve that issue. And say, for example, it says under, is it 7, if there is an agreement, this is the mode of distribution. So the question is the discretion given to the judges. And as judges, we weigh the evidence, and each particular case has its own peculiar circumstances and evidence. Cases are not the same, but the circumstances in this case. Look at, for example, even my brother, the dissenting judge. If you read his judgment, of course, dissent is speaking to the future, and it may be a good law. But in my view, to give the Supreme Court an opportunity when such a matter arises, I was saying, and I will say, this is the amount I will give to the lady. For the Court of Appeal, Supreme Court to start from a premises, this is what the dissent says. Therefore, we either reduce it or give it. And that is how even on damages, that is how even when you are dismissing the case, which is on damages, you give such that you give the superior court an opportunity to assess your position.
Okay, thank you, Judge. And I do commend the bench in the Elizabeth Wanjiru Jonjo Rubia, where you, as you rightly stated, where in a succession matter, which is silent, the law of succession is silent on whether you can address the issue of matrimonial property in a succession matter, and in your bench you are able to give a widow 50% of the property, despite the law being silent on matrimonial property. My second question is with regards to Muruatetu 2. And I will just highlight a few things that the Supreme Court has clarified. Clarified in that particular matter is that Muruatetu 1 did not invalidate all mandatory or minimum sentences. And if anyone wanted to challenge those other provisions, they needed to first file a matter before the High Court. It should go through. Oh, I should put. Okay, sorry. If anyone was dissatisfied or was not okay with those provisions of the law, they needed to first start with the High Court, and then the Supreme Court would then address it when time comes. So along the way, in 2022, there was a decision by the High Court, that is Maingi and 5 others versus the DPP, which was a constitutional petition challenging the mandatory minimum nature of the Sexual Offences Act. And the court held that whereas it's not unconstitutional, but it did violate Article 28 of the Constitution, and sentencing must allow mitigation, proportionality, and consideration of individual circumstances. That matter did not move up. So as is, it remains a decision of a court, a constitutional petition. And then thereafter, the Supreme Court in Republic versus Joshua Gishuki Mwangi, and again, more recently, Republic versus Evans Nyamari Ayako, they reaffirmed that such issues, because there were issues that were addressed in the middle of a criminal matter, and at the Court of Appeal stage, the Supreme Court reaffirmed that such issues ought to have, should go through the proper channels. It came through the Court of Appeal as a by the way, but at the same time emphasized the need to goals such as deterrence, public safety, and sentencing consistency. So there appears to be, in one hand, the Supreme Court, yes, has pronounced itself that if you are dissatisfied, if you wanted to have issues of mandatory minimum or any other matter, you should move through the High Court process. But at the same time, it has made pronouncements that critics say it has constrained judicial reasoning. So my question is, based on the Supreme Court directions and authoritative guidance, how would Kenyans draw the line, or even the judiciary draw the line between the Supreme Court giving authoritative guidance and the High Court left to develop constitutional jurisprudence in the first instance, especially when it comes to the issue of Muruatetu? And what, because I have seen courts still apply the Justice Odunga's decision in Maingi and 5 others to do away with the mandatory minimum sentence. Both the High Court and also the Magistracy Court. There seems to be inconsistencies around that area.
Okay, thank you very much, Commissioner. I think I don't know what you are calling Moriotetu.
Moriotetu, the direction.
No. You know,
it's known as Moriotetu, sorry.
That
I think you understand what I'm saying.
That is Moriotetu 3, in my view. Okay. And there is Moriotetu 1, which is an excellent decision on joinder. On the interested parties, that is Moriotetu 1.
Okay, then I agree with you, then we can
and
go
then
to Moriotetu 3.
I think now there are 6. Moriotetu has now reached 6.
Okay.
If you take into consideration Manyeso and Mangi Gishuki. I have been a criminal judge for quite some time, and we deal with criminal cases every other day. I will not say anything about the Moriotetus, whether they are number 1 or number 2 at this stage. But if you can remember when I was starting the interview, one of the qualities which I will bring is inter-court dialogue. And that inter-court dialogue will bring a conversation between the courts, especially the Supreme Court and the Court of Appeal and the High Court, and say, what is the effect on this decision? Because the you can get, if you want to know the impact of a decision, it is workability, it is application, and the way it is applied consistently or inconsistently, you only ask the magistrates and the judges who do criminal cases. We have a feedback as judges and magistrates on these Moriotetus. The AG was given an opportunity to solve this problem. It was not solved. The feedback is that there is issues. I can tell you, Commissioner Moriotetu, whether it is 1 or 2 or 3 or 4 or 5 or 6, it's one of the most misused and misunderstood decisions. And it is one of the most misapplied decisions. For example, recently when we were doing a criminal appeal, we had a case where 2 people were charged with murder. One was released on Moriotetu. The other one is before us. And when we asked, where is your colleague? We were told he was released by a magistrate. He made an application. The procedure we have in Nakuru, for example, is that all criminal appeals filed will appear before us for mention. And we had several cases where people were convicted for Sexual Offences Act under 8.1 or 8.2. And they come before us and said they were sentenced to life imprisonment by the magistrate. And then were given, when we mentioned their name, we were told by the prisons they were released by a judge. When? 2 weeks ago, 3 weeks ago, or 1 month ago. And the matter is pending before the Court of Appeal. These are the conundrums and the tensions we are feeling. That's why I'm saying it is not in my place, for example, sitting here to say, this one, I think it should be done like this. This one should be done like this. But there is need for the Supreme Court and the Court of Appeal and the High Court judges to have a conversation or a dialogue on this misapplied, misunderstood jurisprudence from the Supreme Court, especially this Moriotetu. Those will be my answers. And I am only waiting for that opportunity to say, this is how it should be done. You see, the Supreme Court has no police to supervise how its decision is being used or misused. But if you give judges and magistrates some window, they can come up with different interpretation. The question one should ask, for example, was this tension there before Moriotetu? The answer, I have no answer. Secondly, this is a precedent which has been set by the Supreme Court. It is the responsibility of the judges and magistrates to comply with that precedent or to follow that precedent. But I will add one thing, one caveat. Precedent is not an inexorable command. It is not. If there is a problem as a result of its workability, its application, the court can be invited to, or given an opportunity to say, this is the position people are, this is what people are doing with this judgment. Is there a way out? That's what I'm saying. We need an intercourt dialogue or conversation on Moretetu. Thank you very much.
Thank you. And other than intercourt dialogue, how about other actors? Because the Moretetu also seems to be bringing a lot of tension with the other justice actors. DPP, police,
in fact,
lawyers.
Yes. In fact,
today you go with this decision.
Yes.
Another time you go with this other one, whichever favors
in fact,
you.
That is one of the dilemmas where advocates, when they appear before us, they tell us, this client was released, but this one, you want to hear his case. So we need to have maybe a larger group, advocates, prosecution, AG, and even members of the public, especially the civil society, and say, what is the way forward about this decision? The correctness or its incorrectness is not in my position, but there is need to have that conversation about this decision.
The implementation of
yes.
that act. Thank you, Judge, and I wish you.
Thank you very much.
Thank you, Justice.
Chief Justice, just one clarification.
Okay.
Because of this case, the Resma case, the judge has caused a lot of controversy also and criticism. I just wanted to know what your view is. Was this a matrimonial home, number one, the issue that was in contestation? And in your view, does a property become a matrimonial home because the family stays there, they've done their, the children have grown there, they rear their chicken, that sort of thing? And lastly, will have the result been different? Because I'm looking at paragraph 21 of your judgment, where you crystallize the issue as coming under the Married Women Property Act of 1882. Would your decision or conclusion have been different if, just out of debate, it will have come through the Matrimonial Act, the Matrimonial Property Act? Thank you.
I don't want to speculate whether it comes under the Matrimonial Act, but I said when matters come under the Matrimonial Property Act, I have made decisions.
Yes.
Which I believe is correct.
Yes.
But if you read the Supreme Court decision in JOO,
yes,
which we certify, it has a very clear directions. The status of marriage or the period is not a factor. The determinant is whether a party has fulfilled its obligation or in terms of contribution. And the contribution can mean direct or indirect. So the court said you must show or demonstrate how you have contributed to this property.
And what was this a matrimonial home in your view?
In my view, it was not a matrimonial home. The matrimonial home is where the lady sold in Nyahururu.
Okay.
Yes.
All right. Thank you.
Thank you.
Thank you, Justice Joki.
If you'll allow me just to pick up from where Commissioner Mwanza has asked about in Resma. Can one have more than one matrimonial home? So that you can have one in Nyahururu and one in Nakuru, and you are staying in both. So that, I don't know if that's something that you considered, that they are both matrimonial homes. If you can just, that was just my pending question. On Resma, I felt a little bit concerned or worried or pensive, or I wanted to analyze this when I looked at the dissent. So the dissent says that the husband in court actually confirmed that this was a matrimonial home, that he did sell the property in secret and that his wife has been contributing in such a way as to help with the mortgage. That evidence, I find it in the dissent, but it is not in your judgment. And I wanted to know if there was a reason that you discarded that evidence.
Okay. Thank you very much, Judge. There are two aspects. There is the original evidence, which is the affidavit filed by the husband, which is almost 35 paragraphs. This other evidence, which the judge referred to, was made 8 years into the dispute.
By the same person?
Yes, by the same person. Mm-hmm. By the same person. After the death of the lady, he filed an affidavit and said, now my wife has died and I have sat with the children and I think this should be left to the children. So that is one of the reasons why we have said, these people, is it a matrimonial dispute or is it a commercial dispute or is it two people who are colluding to defraud an innocent purchaser for value? So this evidence is separate, is different from the one. And if you read the file correctly, we have analyzed all those things in my lead judgment, and I said, this is what this man said. But 8 years down the line, he has changed his position and said, I want to pay an installment of 15,000.
Okay.
And if you are in my position, you will rule in the same way.
I don't think so. But the matter was not before me.
Yes.
But I'm just saying that given the jurisprudence that has been developed over the years around matrimonial property, around spousal consent, even beneficial interest between husband and wife, the criticism out there is that you seem to have upended jurisprudence of many years to settle this question on matrimonial property. So that is why we are asking these questions.
Judge, I'm very happy that you asked this question. And it's not that I have anything. And as I said, the role of the judge in any particular dispute, especially a judge who has dealt with an appeal, is to look at the evidence and find out where does this evidence lead. The question is not whether it is a man or a woman. If it was the other way around, what will a reasonable person rule in the circumstances of this case? Here is a man who says in his evidence, which he filed within a month after the sale of the property, and he said, my wife knew. And then Rasma says, this woman knew, the lady knew. We went to her house, and there is a documentation from Rasma saying, give us 1 month or 2 months before we move out of the property, or otherwise we pay 13,500. Under these circumstances, it is not a question of man or woman. It's a question of where is the justice of the case. And the justice of the case, you don't know, for example, my lady, whether Rasma, there's a woman behind Rasma. And under these circumstances, for example, this case was decided, I think, 14 years after it was filed. 14 years down the line, these people are keeping the box and the money.
I think, Judge, you've made your point.
Yes.
Let's not rehash it. Let's move on. I was listening carefully after Commissioner Shchale and Commissioner Mwanza asked you questions, and I just want clarification on a number of issues. Did you say that what you believe is that a court should only look at the rights that are to be found in the constitutive text only? So such that the rights that Commissioner Mwanza had talked about yesterday, unenumerated rights. The rights are there, but they are not in black and white in the Constitution. That is something that you would not look at. I just wanted to affirm that that's what you meant. And then I thought I heard you saying that you think that the Supreme Court should focus on the issues of rights and not on matters of general public importance. Did I hear you correctly? I just want to be sure that I heard you correctly.
So
before I follow up.
Maybe you repeat the question. Which one do I answer first?
You can answer one after the other.
The question of rights. And I say this. The role of the judge is to look at the law, the Constitution, as the guiding compass. And judges, in my view, should not exercise what is called raw judicial power. Anytime when a dispute arises, they must look for something because something has been raised. The question I'm saying, in the context of a dispute, it is not a question of whether the right is black or white. The question is whether the Constitution, rightly understood and rightly interpreted, provides for that right.
So how then will the Supreme Court develop rich indigenous jurisprudence if they are confined only to text?
Judge, the position is this. We have been given a document. That document may not be perfect, but this is the will of the people. This document binds all of us. We have been given the tool of how to interpret it. And one of the principles of interpretation is this. Judges should guide against their ardent view of what the right ought to be. But they should only deal with the right as is stated correctly in the Constitution and as in the statute. And secondly, if the right is not provided, there are two issues. Whether there is ambiguity, or secondly, whether it is expressly denied. Do you want to have a situation where judges go into a free, they call it what? Free policy making decisions, free willing decision making, that the judges every day, because this is what they think, or this is what they think ought to be, they are making decisions on their interpretation. Where will that leave the constitutional text?
Okay. I think we can continue to argue about this. It's about how the judges balance. But let me move on to the next question, which also emerged from the questions of the other commissioners. When you look at Dari and Cholet, for example,
yes,
both considered the duty to sit and both had different outcomes.
Yes.
But the facts and findings, the facts of both cases were also different. Are you familiar with how the decision in Dari was made vis-a-vis the decision in Cholet? And if so, are they distinguishable?
I am aware the circumstances and the facts of both cases. The court made a very comprehensive, rightly in my view, in the case of Cholet. But in the case of Dari, and it's not my position to say anything negative or positive about it, it is the same circumstances, the necessity to sit. The question I'm asking, in view of the numbers of the court, and it is constitutional responsibility, what happens to a party who has filed a case before the Supreme Court, and it is the Supreme Court that allowed him entry into that door? How will he deal with that matter? When, for example, maybe everybody will raise allegations against the judges, rightly or wrongly. And as judges, people will criticize us, sometimes even scandalize us. But how do we react to such criticism? Is it the court to say? Because the question, judge, was not a recusal before the court. The question was stay proceedings. This man was saying, stay proceedings as I prosecute my matter before the JSC.
Yes, and what he had said
Yes.
is that the entire bench is biased and he does not think he can get justice from the bench. And there are no other Supreme Court judges other than the bench. So what would you have done in those circumstances?
No, I'm not saying I will not have what I have not done because I'm not a Supreme Court judge. But if I aspire, yes,
but
God willing.
In those circumstances, is there an alternative?
The alternative would have been to wait for application for recusal, my view, to say recuse yourself. But there was
you're suggesting, so the court should not have moved itself so moto.
Yes.
It should have waited for an application.
For an application,
I
yes.
see. Okay, I have understood that. Now, there's a question that came from Commissioner Mwanza, which I didn't think you answered, as to whether the Qadhi's court is bound by the Supreme Court decision in Faraj. Is it bound?
Of course, yes.
Okay. Secondly, you seem to suggest that although the Faraj matter, you're suggesting that jurisprudential outcome is sound, but the manner in which it was dealt with is not. So I'm just trying to identify what you would have suggested is the way a court should have handled it. Should the High Court have referred the matter to the Qadhi's court? Should the Supreme Court have referred the matter to the Qadhi's court? What do we do if the parties have chosen the forum? Can a court say, no, you cannot come to the High Court, you must go to the Qadhi's court? It's the parties who choose the forum. So how can a court make that decision?
I did not question the merit of the decision. What I question is the methodology.
Yes.
And the methodology is this. It is not the parties which chose the forum. For example, the appellant did not choose the High Court. The High Court. She was before the Qadhi's court, but she objected to the proceedings before the High Court. And if you see if I look at the matter correctly, the judge proceeded under the Islamic law. He did not proceed under the Succession Act. And he said correctly, Section 2 of the Succession Act precludes such matters. Here are parties, all of them Muslims. None of them, the lady, for example, the appellant, did not submit to the jurisdiction of to the High Court. So there is a provision under the Civil Procedure Act which provides, for example, if you need an expert witness under the Evidence Act, matters involving Islamic Sharia, even the Supreme Court could call for that expert evidence or expert witness to assist the court both in the High Court, in the Court of Appeal, and in the Supreme Court. But the dilemma I'm asking, this case, the methodology is wrong because the child, as much as you have protected, will live with that trauma of being given that name. If the matter would have been taken to the Qadhi's court, that name will not have existed. That's my position.
Okay.
Yes.
Thank you very much. I've understood. You've also said something which I wanted you to clarify. You've said Islamic law is not ordinary and cannot be repugnant to justice. Is that your position?
Yes.
So the Constitution, the constitutional command that says that where a culture or even religion is repugnant to justice, then we must follow the Constitution. So which path do we follow? The Constitution?
I don't know. What I said, Judge, is this.
Uh-huh.
Islamic law, in its proper construction and understanding, is not an ordinary law.
But is it subject to the Constitution?
It is subject to the Constitution insofar as infringement of a particular right or in terms of, and I say this, the Constitution is supreme. But what I said is this: the courts should avoid a situation where it is constitutionalizing the Islamic law. It should allow the other way around. Islamic law must be interpreted and calibrated in accordance with the constitutional provision of proportionality, and ask whether it is inconsistent with the text of the Constitution. And that's when you can say a violation has occurred. But before that opportunity has been arisen or has been given to the Qadi's court, the court should not rise and condemn the Islamic Sharia simply because it did not understand, or it did not look at the avenues open to it to address the same issue. And I said this: Islamic law, properly understood, is just, is benefit, is fair. Any interpretation that leads to oppression or injury to the innocent is not part of the religion.
Okay. I have understood you now.
Language is a problem.
Let us move then a little bit from jurisprudential matters to rules of procedure of the court. I'm sure you're familiar with the regulatory framework of the court. You will recall that in 2018, the Contempt of Court Act of 2016 was declared unconstitutional. So what is the regulatory framework for courts to conduct contempt of court proceedings? Courts in general and the Supreme Court in particular?
I will say there's a provision in the Supreme Court rules, I think Rule 29 or something like that, which talks about contempt before the court. And it says the person, if he commits contempt before the court, he can be detained, then he can be given an opportunity to respond, and the day after, the court can deal with the contempt. If it involves an advocate, it can bar him for 1 year.
Yes,
yes,
you are correct, because
yes,
the Supreme Court has its own regulatory framework to do that. What about the other courts? Because actually we have it in the Act and the rules, but what about the other courts, the superior courts? Because the Contempt of Court Act was declared unconstitutional. What do other courts do?
Then you refer to the Judicial Act.
Okay. Yes, I think that is the way to go. I was listening to you carefully when you made your initial statement, and as you're speaking, and if I didn't know that you were sitting for an interview of a Supreme Court judge, I would have presumed that you are sitting an interview for a Chief Justice, because because you have you are looking at challenges of the entire institution.
Yes.
And I can see you've been the presiding judge in many of the courts. You've been a commissioner for 10 years. You have very strong administrative skills, and you've been very senior. But the position that you have applied for is the most junior judge in the Supreme Court. And in the Supreme Court, we have a precedence, and seniority is taken up very seriously. The other thing, when I was listening to you, I heard you saying that as a presiding judge, you have given directions, and you use the word "I" a lot. I said this, I told the judges this, So, the regime, that the regulatory framework of the Court of Appeal is different from the Court of Appeal, because in the Court of Appeal, we take decisions together. That is the command of the Act.
Supreme Court.
The Supreme Court. So, there will be no "I", there will be a lot of "we's". But I'm just wondering, are you able to come down from all the senior positions that you've held to come to being the most junior judge in the court, and to be able to be given administrative tasks by the other judges who are more senior to you? Will you be able to manage that? Because it is, you're going up, but actually you're also coming down. Is that something that you can manage?
Very easily. Honorable Commissioner and Judge, I have worked under 4 Chief Justices. All of them were bosses. I have never in my life And I have been given various responsibilities, starting from Gisheru, who gave me the first opportunity. I have never in my life, gone against my Chief Justice. Here is a very easy task for me. When you have been a leader in a collegial court, it is very easy, especially when you are in a court of 42 and you have been also there as a leader and as a presiding judge. It is very easy to fit in a court of 7 people. 3 things. First of all, I believe my role will be a chief whip of the court. That's what I think so. The Chief Justice will be in direct contact with me to give me directions. The DCJ and the Commissioner, those are my 3 bosses. And these others are also my colleagues. And I have worked with all of them very closely in different positions, either in the Commission or as a High Court judges or in the Court of Appeal judges. So that will not be an issue. Having come from a court of 42 people to fit into a court of 7 people. And I said this, mine has always been service to the people. And to fit with the court or individual judges, in fact, that is one of the things I enjoy. And it will not be a problem.
Okay.
And I will take lawful commands from you.
Yes. I understand that.
Yes.
But let me repeat.
Yes.
It is a court of equals, but seniority is taken very seriously.
Yes.
And therefore, there is no consultation you'll be doing with the CJ and DCJ without the other judges. We take decisions together. So I just want you to have that in the back of your mind, because it's very different from the Court of Appeal. But if you come, you will see what I mean. I'd like to go to the issue of the need for judges of the Supreme Court to be considered to be impartial, to be considered apolitical. I've been in the court now for 15 years, and occasionally people will remind me that I used to be a member of parliament, even though that was 19 years ago. And as a judge, there is a certain way you have to engage to completely keep away, to ensure that people see that you're impartial and apolitical. I was looking at a date here. Let me be very specific. So, on August 23rd, 2023, you were in Mandera, and you were on a platform in a public place where you said these exact words. But I know when I retire from the judiciary, I want to be governor here. The governor then followed up and confirmed, yes, when I finish my term, Justice Warsame will be the next governor. Now, if I, Njoki Ndungu, was to go out there as a Supreme Court judge and say in a public place that I will be the next governor of Nairobi, I can assure you it will have impact not only on myself, but on the court, because we are the last court, we are the political court, and therefore we have to be very careful with what we say. But now that you said it, do you have political ambitions? And is this something we have to worry about in the court?
If you listen to me, that it was not, first of all, the 23rd August 2023. It was somewhere, I think, in December, and we were in the company of the Chief Justice.
She didn't say anything. I'm asking you what you said.
Yes, and this is the answer. And it is within the right of judges to make certain comments, provided it doesn't affect their responsibility as judges. And I said, when I retire from the judiciary, I didn't say I'm coming to be next governor. And you know, the governor of Mandera said, after I retire, and that is 2032. So there is no problem. Maybe I will want maybe one day to become a governor of Mandera if my people call me. But that will not affect my responsibility as a judge, and it has never affected my responsibility. And the judge, take it to the bank. I am the most impartial judge. I have an impeccable character in terms of integrity and in terms of impartiality. If you see my JSC file, it is so thin. It has only transfer letters.
If we can just refocus.
Yes.
You see, Judge, my worry would be this. We are the Supreme Court, we are the final court. We get, for example, hypothetically, a petition involving the governor's election in Mandera. Because of your comments, will you sit out that matter? You've just repeated it, actually. You've even said you are still interested in being in politics. I hope you're understanding my concern.
No, I didn't say I'm interested in politics.
What did you just say?
I said when I retire from the judiciary, I may. That's the word I used.
So you're still showing some kind of interest in politics by that statement?
You see, it is always good to show aspirations as a human being. You must be hopeful that one day, even when you retire, you can become something else.
But can a Supreme Court judge make such a statement?
I'm not a Supreme Court judge now, but when you give me that opportunity, I will decide what I will make within the confines of the Constitution.
Okay. So that is one thing I was concerned about. And the video, I watched the video last night. I was quite surprised. The second one goes to issues of judicial temperament. Now, in the Supreme Court, again, the way we engage each other as a court, we listen to very controversial cases. We have to engage each other collegially. We have to show each other respect. And so certainly judicial temperament is important. The other thing that is important is the issue of conflict of interest, that one should be able to state if they have a conflict of interest and avoid being engaged in anything that they would have a conflict of interest. So there is an interview that you conducted, and let me see if I got the date right, April 19th of 2021. You were in the Judicial Service Commission as a commissioner, and you were interviewing Justice Matthew Ndumandere. In that interview, which again is televised, you were involved in a discussion with a judge, and you were pressing him to make a comment regarding a judgment of the Court of Appeal. The judgment you were pressing him to make a comment on was an appeal of his own decision. And his own decision was a decision that overturned a decision of the Judicial Service Commission, and it is a decision that you were involved in. So, when you were having a back and forth with the judge, he kept on saying, but judge, you were involved in this decision. But judge, you were involved in that matter. But not once did you say, yes, I was involved in that matter, and drop it, maybe allow another commissioner to ask the question. So even in terms of conflict of interest, so you're conflicted, you're asking the judge in an interview about a decision you're clearly conflicted about, and even when he raises the issue, you still continue to ask about it. What do you have to say about that?
I want to say I didn't intend to offend my colleague. The judge is my colleague in the Court of Appeal. I didn't in any way want to be malicious against him or anything. This is a very contentious matter, as you know. And even the Supreme Court.
The Supreme Court has settled the issue.
Yes, I know.
But at the time of the interview, the Supreme Court had not settled the issue. But you're asking the judge, I mean, you know, we talk about judicial independence. You're asking him to explain himself about a decision he made. But the decision he has made involved a decision you had made. It's direct conflict of interest.
Maybe, Judge, is the way you look at it. I didn't question his decision. I questioned his words against the sitting Chief Justice, against the fellow colleagues, judges, like myself. And I told him, if you can read the document and correctly, was it right for me to say, as a judge sitting, to criticize my Chief Justice? And that's what I was asking. I didn't ask him about whether he had a conflict or not. I asked him whether he had used the appropriate words against the Chief Justice and colleagues.
But you can imagine a person who is neither you or me, who was watching such a video and is aware that this judge has overturned a decision you have made, and that you are interviewing him on that same decision. I think they would raise the issue of conflict of interest that you did not declare, and perhaps you should have.
Maybe on recollection.
Okay. Further to that, there is another matter, again, another video of you interviewing the former Justice Ojwang. I believe that in 2016, the interview was in September 15th, 2016. And you were also having, you were talking to each other. And I have two questions. One, you told the judge that he had been found culpable of misconduct. And your back and forth went until Justice Ojwang said, "Give me a break." And then he looked at the chair of the commission and said, "I need protection from this particular commissioner." That video, if you look at the comments, they say there was a heated exchange between the two judges. Some people think Justice Warsame was bullying Justice Ojwang. Other people think that Justice Warsame must have a personal vendetta. But apart from the description that it was, a combative interview, again, when you asked Justice Ojwang about the fact that he had been found culpable of misconduct, again, it went to a decision of the Judicial Service Commission, which was in court at the time. So the matter was sub judice. So, and you didn't mention that. So how do you bring up an issue which is sub judice, again, a matter in which you had made a decision and it is being appealed or it's being reviewed by the High Court? But you brought it up in the interview. So again, there was a conflict of interest, which again, you did not speak to, number one. So that's another one question. But secondly, that the descriptions that are coming out from the public, that you're combative, that you're a bully, is this something we should be afraid of if you come to the Supreme Court?
Thank you very much, Judge. The issue of being combative or there is some description coming up from the members of the public, I'm not aware, first of all. And as a judge, and especially a Supreme Court judge, I have been a judge for the last 2 years. It is very hurtful and demoralizing to accuse a judge of an allegation which is not before him. There has never been a complaint filed against me in my life for the 22 and 4 months I served as a judge.
I'm sorry,
yes.
If you'll allow me.
Yes.
I know there's no complaint.
Yes.
When I watched the video last night,
yes,
there are comments from members of the public.
Yes.
You see, it's out. The video is out there. Then people comment. So those are the comments.
How will I know? Because I have not seen the video unless you are the one who is putting to me. And at least, as to be fair to me,
yes.
And I don't know those things which you're talking about. And unless it is brought to my attention, that is when I can respond to it. And then, Judge, also, you had an interest in the matter.
Actually, you're right.
Yes.
I had. And that's how I know it was sub judice. But I was not the one in the interview room.
Yes.
So I had no conflict of interest. And the matter is since settled, so I have no conflict of interest now. But at that time, in 2016, the matter was sub judice. It was about it. The sub judice matter was an appeal against your own decision. Again, conflict of interest not declared. I'm just saying that.
No, if I may have in any way, in your perception, offended any judge, I must say that was an error on my side and I apologize.
No, it is not my opinion, Judge. I'm sorry. It's not my opinion. I'm just saying, I got this video. It's out there. It's like the live, we are now live streaming. So it was a live streaming of the JSC. And even after today, I'm sure the live streaming, there'll be comments. So I'm just telling you what it is the public was saying about the exchange you had with Justice Ojwang. But more importantly, my concern was the conflict of interest, which I've raised with you. So I think on the issue of collegiality, those are the questions that I had for you, and I think that you have responded to them. And as you normally used to tell those before you when you are commissioner, I wish you well.
Thank you very much.
Commissioner Rwanda, or just Sharia, you want?
Yes, Honorable Chief Justice. I think Justice Warsame should not get away with this. He says that when it comes to integrity, he is number one. I want to enter into a contest with him.
I didn't say I'm number one. The number ones are the commissioners and the Chief Justice.
Thank you.
For purposes of this interview.
Let's leave that debate and go to Commissioner Rwanda.
Thank you, Chair. It's been a very long day. Judge, good afternoon once again.
Good afternoon, Commissioner.
Yes, I wanted to have some discussion with you concerning your performance report from DISPOP.
Yes.
Although I must say, as I'd said to a candidate we engaged earlier, that there's a bit of a challenge there in terms of analyzing performance, considering in the Court of Appeal, you sit on a collegiate bench.
Yes.
I shared with him some statistics, and his view was that it will be erroneous to rely on those to determine performance.
Yes.
If you wish to, you can also comment, but I wanted to just share with you what I have concerning you. You have sat in 9 benches in the period under review, and out of the 9 benches, 8 benches, 8 benches, out of the 8 benches, the performance, and I'm talking, maybe I should just give you a bit of background on how I'm arriving at this, or how the report has brought out this. The performance is assessed on the basis of the benches you sat in, total output in terms of merit resolution compared to the total output of the court, so that even the benches that you didn't sit in are taken into consideration. I don't know if your feeling is that would be okay, but out of the 4 where your performance has been above 30%, I think there's quite a bit of, out of 3, it even went above 50. So it looks like the performance wasn't so bad. But what I want to hear from you is whether that approach would really reflect how a bench, I'm alive to the fact that we're not talking about individual judges, how a bench has been performing. And if there's any challenge that you can share with us, maybe you can also.
Thank you very much, Commissioner. The production metrics is a very complicated document. Sometimes it doesn't measure the output of judges, especially a collegial court. We have always been insisting, especially in the Court of Appeal, and it is easy to perform, to determine or measure metrics in courts outside Nairobi, where there are only 3 judges. Mm-hmm. But the problem is, even in those stations, a judge or 2 of them will go on leave. So the situation will change. A judge who is in Nairobi will be sent to Nakuru or Eldoret, depending on the circumstances. But I think, and this is what we have been saying, there is a need to have fixed benches in the Court of Appeal. Mm-hmm. And that will also show how to measure correctly the output of the judges in a particular bench.
Okay, that is similar to what your colleague had mentioned earlier. Yes. Maybe that is food for thought. We can look at that.
Yes.
But for now, the question that I had for you, I want to read a quote, and I thought of this because in your opening remarks, you told us about your leadership in the institution, and I know you have served in the institution for quite a long time, and you're one of the senior judges that we have around. So I want to get your view on this. If we really want high performance in our organization, the solution isn't to entice people with a bigger carrot or threaten them with a bigger stick, or rather a longer stick. We need to understand the intrinsic motivation. especially that if you want good performance, it's not about how you can punish people or how you can reward them, but you need to understand what is it internally that motivates them. So in your experience in judicial leadership, what do you think are some of the things or the intrinsic factors that would motivate high performance in our workforce, especially in the judiciary?
You see, in the judiciary, some of us are in the judiciary out of conviction. We are not out in the judiciary because of the conveniences and the privileges. Secondly, we have not been attracted to the judiciary like Commissioner Sylvia by watching a TV, which attracted her to the judiciary. The metrics, in my view, is to relook ourselves in the mirror and say, because Kenyans have given us this trust, this privilege, are we able to look ourselves in the mirror and look at and see the black spots in our bodies and say, I think it is time for us to perform. If we have been told to deliver judgment within a specific time, is it possible to deliver it? Secondly, how do you deal with the lifters, the high volume lifters, against the low level lifters? A judge may be doing a criminal appeal or a criminal trial for 6 months, but another one may be doing a criminal hearing and determine maybe 100 or 200 cases. How do you compare and contrast? But the guiding factor is, are we delivering? And the metrics, I think the judiciary, through the Chief Justice, has given everything to us. But the question we ask ourselves as judges and magistrates, are we delivering? And how can we prove production? The question depends on the individual courts and the individual presiding magistrates and presiding judges. For example, in my court in Nakuru and Eldoret, there has been complaint against us that we are listing too many matters. And Commissioner Sichale confirms by our colleagues, we list 6 appeals, while the ordinary courts list 3 appeals. There has been complaint against us. Why are you listing this? And sometimes 15 applications. Is it possible to standardize these things, or does it depend on individual courts? How can we improve delivery? One way of doing these things, in my view, and having worked in outside stations, is supervision. Judges and magistrates need to be supervised. And there are people who are earning huge sums of money, the presiding judges, the registrars of the courts. It shouldn't be left for the Chief Justice to know, maybe after 1 month I am not working. The registrars and the presiding judges should give report to the Chief Justice. Again, and this is very important, there is need for JSC to recruit a registrar in the office of the Chief Justice in charge of productivity, to monitor what is happening in Mandera, what is happening in Nairobi, such that the Chief Justice has a direct report. Again, also, and very important, the question we need to ask is, during Gisheru's time, we used to send our metrics every day before 5 o'clock. Can we go back there? Because we are so many, JSC has recruited so many. Has it translated into an output? Has it translated into a positive production? Those are the conversations which we must have. And I think this is what I have been telling people. We have been having colloquium, magistrates, judges, and all judges. In a colloquium, we should only discuss 2 issues. And the 2 issues is productivity and integrity. Integrity, because It is very important for Kenyans to have an integrity-free court or a corruption-free court. And productivity, because without productivity, then Kenyans are not getting value for money. So in our discussions, whether it is a magistrate's colloquium or a judge's colloquium or a small court of the Supreme Court or a court of appeal, we should discuss productivity. And that's why I said, Commissioner, from when I was starting, there is need to send the leadership team to outside Nairobi. Chief Justice should direct, for example, Judge Njoki to go to Mandera and find out whether the magistrate there is performing. Those are my views.
I think your passion around the issue of productivity is palpable. And now I'm tempted, though I was worried in the interest of time, just to get your view on a question I asked an earlier candidate, whether failure to meet performance targets should be treated as a discipline issue. Just your view, briefly.
You know, having been a leader of judges and magistrates, and they're watching me, I don't want to answer that question.
Maybe you can just share with us your view. What do you think? Is it a discipline issue that we should consider for our consideration?
It should be an administrative issue.
It should be an administrative issue.
Yes.
Okay.
Yes.
Thank you, Judge, and I wish you well.
Thank you very much, Commissioner.
Thank you, Commissioner Sirani.
Thank you, Honorable Chair. Justice Warsame, good evening.
Good evening, Commissioner.
You can take us.
Yes.
I'm having a challenge with the sound system. I hope you can hear me now.
Yes.
Okay. Now, having been a commissioner at JSC and also in the leadership of the judiciary, you know that we place a lot of weight on mentorship. What role does mentorship play in ensuring continuity of rule of law and the administration of justice? And how would you measure the success of your mentoring efforts, maybe with specific incidences that you can give us of where you've mentored and what results you may give for that?
Thank you very much. Mentorship is so important to judges and magistrates, especially when a judge is new or a magistrate is new. He needs somebody to hold his hand and directed him in the right direction. The route he takes will determine his future. And I have mentored many judges and magistrates. For example, all the judges who worked under me in the JR became Court of Appeal judges except one. Except one. And because of the mentorship I have given during the time I worked with them, either as 3-judge or under me, I was also sometimes, most of the time, in charge of the Constitutional Division, because Judge Lanola was who was in charge, was in Arusha most of the time. So the Chief Justice also directed me to be in charge of the Constitutional Review. So all the judges who served under me, both in the JR and in the Constitutional Review, ended up in the Court of Appeal through my mentorship.
So how do you measure your success?
I measure my success because many of the people I mentored, some of them are in this room. I think I can say I have an excellent mentorship qualities.
Okay.
Yes.
Thank you for that. What is the role of emotional intelligence in the life of a judge?
Yes.
And in what incidents would you apply emotional intelligence in your work?
Thank you very much. You are sounding like Professor Mugenda, because that was a permanent question for Professor Mugenda when we were together. Emotional intelligence helps to cool down difficult situations and positions. It is a way of maneuvering difficult circumstances to get a good result out of the position. I have done that many times in the commission and as a judge. I have presided over very difficult cases with my colleagues, and I think through emotional intelligence, we have always achieved a positive result. And one thing, when you are applying emotional intelligence, you have to apply wisdom. And when you have to apply wisdom, you need a lot of qualities, like you must be patient sometimes, you must be able to diffuse the situation, sometimes making one or two jokes, such that you keep everybody within par. So, and sometimes, emotional intelligence, when you are dealing with very contentious matters involving contentious advocates, you need a lot of wisdom and a lot of emotional intelligence, and which has helped me in my life as a judge.
Okay.
Yes.
Just to answer you, maybe I sound like Professor Mugenda because I replaced her to represent the public.
Yes,
we have
thank
the
you.
interest of the public at heart. Now, I will move to some of the feedback we received from the public. As part of this process, when we are recruiting, we normally seek feedback from our stakeholders. And we have quite of good things that have been said about you, Judge, and that is commendable. There are concerns that were raised by some people who said your interpersonal skills are wanting in the manner that you're straightforward, and sometimes this rubs people the wrong way, while others felt that they are, once they get used to working with you, then you're very amiable and easy to work with. So I wanted to know, how do you balance your straightforwardness to ensure that you maintain good relations with others at all times?
Thank you very much, Commissioner. One thing I have, and which I always, God has given me, I have a golden heart, which accommodates everybody, no matter his position. I can relate with the T-boys in the court, and I can also relate with the Chief Justice. And we've never had a problem in terms of personal relationship. The problem is one. Many people tend to know me, but they don't understand me. But when they understand me, they get the true position of Judge Warsame, which is a man who has a golden heart. I'm not a great judge, but I'm a man who has a golden heart.
Okay. Fair enough. Now, apart from the professional referees and character referees that you provided, I also wish to highlight that we received recommendations from LSK North Rift and LSK Nakuru chapter, and I will just briefly say some of the things they've said about you. LSK North Rift have said that you distinguished yourself as a principled and intellectually gifted judge, significantly contributing to the Kenya's jurisprudence in constitutional, commercial, and public law. And they were happy in the manner that you handled the Eldoret court prior to establishment of a permanent court of appeal in the station. Nakuru chapter said you spearheaded innovative and effective measures aimed at addressing case backlog, expediting and hearing and determination of appeals. They said that your turnaround time was very efficient and you made access to justice easy for all. So from my side, I would just wish to say keep up the good work, and I wish you the very best, Judge.
I'm humbled.
Commissioner Kisoto.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you, Commissioner.
Let me start briefly with your introductory remarks, where you said the Supreme Court must carry Wanjiko or the ordinary citizens along, its decisions is music to the ears of many Kenyans. Because a lot of times, most of us or most Kenyans struggle to understand how the Supreme Court can be more accessible and accountable to the ordinary citizens and not just the elite legal practitioners. So other than in the decisions, how else can the Supreme Court be more accessible and accountable to ordinary citizens? Just give us three more ways.
I think this is what I said. There is a need for the Supreme Court to reintegrate with the public by even going to barazas and even having a discussion with people about what the Supreme Court is. Again, it is important for the Supreme Court to exhibit servant leadership in terms of the fact that, it shouldn't be a court for a certain group or certain members of our society. The people of Mandera and the people of Narok should know what the Supreme Court does. Let me tell you a story. Commissioner, 2 weeks ago, and this is for Commissioner Njoki, one of my relatives in Mandera called me, an elderly lady. And she said, we want to pray for you. But where are you going? Because you told us the last time you work in the Kenya court. And we know the Kenyan court. It is the court that deals with criminal infractions within us. But which is this court you are going to? So I could hear. Then another lady said, no, I said I'm going to a court higher than the Kenyan court. And then the other lady said, are you going to the court of the Mzee? Then I said, yes, I'm going to the court of the Mzee. Then the lady asked me, now that the Mzee has died, what will you be hearing? The Mzee meaning Raila. The impression of the people, for example, in that small village is that this is a court that was only dealing with a dispute involving Raila Amolo Odinga. And there is a need to disabuse people and show them the Supreme Court in terms of leadership and in terms of jurisprudential leadership and institutional leadership is available to the people of Kenya. It's available to the Wanjiku. And it doesn't mean that all the cases will reach the Supreme Court, but it gives people confidence. It gives people presence. It gives people hope that if a magistrate or a judge in Mandera misbehaves or gives a bad decision, there is a court that is available to them, where even the Chief Justice and the Deputy Chief Justice sit. That is what we expect from the Supreme Court. And that is one of the qualities which I will take to the Supreme Court, if given an opportunity.
Thank you. Now, suppose a Supreme Court decision benefits powerful political elites while disadvantaging marginalized communities. How should the court ensure that constitutional interpretations protect minority rights? And please, you could actually illustrate this with an example.
Thank you very much. The Supreme Court, in an ordinary circumstance, it will be treason for me and for you to say the Supreme Court has given a decision which is given power to something to powerful people. So you should at least, Commissioner, say maybe something elegant or moderate. So I want to say this. The Constitution protects the rights of the marginalized minorities. In particular, Article 56. So there is a mechanism to protect minorities and marginalized. And there is also, the law gives certain things like, for example, they call it what? There are certain funds which are meant for the marginalized communities. But one thing which the court should emphasize, and this is the defining factor, is the issue of the money which is given to devolution. The court must support that, and affirmative action, and many other issues which I think supports the marginalized and minorities. And in particular, in terms of employment, in terms of their rights, those things.
Okay, now suppose technological advancements as artificial intelligence, which is now an emerging frontier, create legal questions. We often hear that AI hallucinates. What approach should the Supreme Court take when interpreting the Constitution in such emerging context?
There is no framework regulating AI. But I think there is a framework which was issued by the Chief Justice. I'm not very sure. I think there is something which was issued by the Chief Justice, which is meant to assist in access to justice. It is a very complex issue, but also it has its advantages. Its advantage. But the question is, how do you regulate AI in terms of how it is being used? AI is a simulation of our intelligence. I think some human beings are ahead of other human beings, so they have created AI. The question is the legal aspect of this. There are people who are generating pleadings. There are people who are generating authorities. There are people who are generating affidavits and everything, and putting it before court. The court has to be very, very vigilant and find out how to moderate this. I think the CJ's regulation, or framework, is the way forward in terms of regulation. I have seen there are 4 judges who have commented on this issue. The problem first was confronted by Justice Magare, where there were documents which were falsified, which were filed before him. Then there was also Judge Lenola, who gave a lecture sometimes back last year. And then there was a recent decision where Judge Chikiti and Mamuye dismissed matters because they used AI in a certain illegal manner. So the question is a balancing exercise. It is in the right direction, but we should avoid abuse and look for a way to regulate it. But it's a positive step, and it can assist access to justice in terms of harnessing technological positions. So it is good, but it has its negatives. The question is there regulation other than what the Chief Justice has issued? There is need to have a proper statutory regulation, in my view.
Right. Now, finally, in a constitutional case before the court, and the intelligence agencies claim that disclosing certain evidence could compromise national security. In your own view, because if the evidence is essential for determining the truth of the matter, how should the Supreme Court manage this tension between the national security and the need for transparency and fairness in the judicial proceedings?
Thank you very much, Commissioner. These are 2 competing interests: public interest and the individual's interest to a fair trial. It needs a balancing exercise, and it depends on the context and on the case before court. The issues one can prejudice or damage public interest or public safety. For example, the question is how the extent you can go in terms of the prohibition or limitation. If, for example, it will damage our relationship between another country, there is need for the court to interfere. For example, if it is meant, for example, to hear or to regulate an investigative method, and somebody is saying this investigative method which was used to prefer judges against me must be brought before court. I think that is an issue which the court should concede in terms of public interest, investigative techniques. But there are instances where I have seen in some Commonwealth countries, there is need for reduction or need for special sitting where the information is only given to the judges, but there are advocates who have been approved in terms of security by the state or by the court to appear before court because they have been approved, because of the sensitive nature of the matter. If, for example, the person will leave the jurisdiction of the court or is about to commit an offense, the court can regulate. For example, if the information, because we have an information where there is a documentation issued by an advice given by the Attorney General, and somebody steals that information and this Honorable Attorney General has written to another arm of government, the question is whether it can be used simply because it has been unlawfully obtained. So these are balancing exercises. And I think that I had done a case where a communication coming from the Attorney General was intercepted and was used in a case. And I said, no, you can't use because you are interfering with public interest and the power of the Attorney General to communicate freely and share information in respect of the advice and opinion he's supposed to give various arms of government. Thank you.
Thank you very much, Judge. I wish you all the best.
Thank you very much, Commissioner.
Yeah. Thank you, Vice Chair.
Thank you very much. Judge, I hope you're not tired.
No, I'm not tired.
You can still go on and on.
Yes.
You just mentioned the public interest and national interest.
Yes.
What's the difference?
Public interest has two synonyms. We are part of the public interest as an individual, but the national interest is the bigger one that involves our nation.
Mm-hmm.
Yes, so public interest in the administration of justice means that you have to treat people fairly, equally, and in accordance with the law. But national interest is different from public interest, and this one has a higher threshold than public interest.
Okay. You were discussing globalization.
Yes.
On technology. How is globalization also affecting now the local jurisprudence and the administration of justice, other than AI and the other technologies?
I'm not
globalization on.
Thank you very much.
Networking, yeah.
Yes, I think the world has become a village, and the village in America is also the village in Mandera, provided there is that information available. How it has affected is that, what was available there, for example, in the Court of Appeal, the virtual hearing, you can join the court from America,
mm-hmm.
give evidence,
yes.
You incur no expenses. And that has really transformed the Court of Appeal in terms of technological advancement.
Fine. How would you promote the societal interests together with mentorship if you were to ascend to the Court of Appeal?
That's why I said what I bring on the table, Commissioner Vice Chair, is diversity. Yes. And diversity means inclusivity. And we are all human beings first and foremost, but we come from different areas. The Supreme Court, in my view, should take into consideration and have everybody on board. And I said, the judgment of the Supreme Court is not the elegancy, or it's not about the quality of the decision. The decision must be legitimate, and it can only be legitimate when you carry every member of our society on board, and they're saying, this is our court, this is our way, this is our constitution.
Okay, thank you.
Thank you.
Thank you.
And thank you, honorable commissioners. I think the hour is late. I do not want to tire you, Judge, again with more questions, save to let you know that the very active in talking to people in mentorship. Judges routinely give lectures in the universities, and it's in our calendar of activities where we go around the country meeting with the students. We also have town hall engagements with the people. So if you are successful, I think you will find a forum, plus of course the Judicial Dialogue Day and other activities that I, as the president of the court, engage in. I have, I think, visited all the counties out there. So there is a lot of outreach. So it's just that what you did last year cannot be remembered. You need to duplicate it every year. And of course, time becomes very scarce. But thank you for those observations. We've now come to the end of the interview, but I was looking at your papers. One, you indicated you have a Master of Law from the University of London, but you did not.
No, I did not.
Eh?
I did not.
It's not yours?
No.
Oh, okay. Somebody else's piece of paper I think found its way in your folder.
Yes, not me.
Okay. Sorry about that. Yeah, so I think now is the time we give the candidate to also engage us.
Thank you very much, Honorable CJ, for giving me this opportunity to appear before you. It is also good to appreciate being the other side of the chair. I really appreciate and enjoyed the interview. I wish to sincerely thank you, Chief Justice, and all the commissioners for giving me this opportunity. Chief Justice, my last word is that Justice Gisheru gave me an opportunity and gave me one advice. I have kept that advice. Mutunga also gave me an opportunity to come to the Court of Appeal. Give me an opportunity to go to the Supreme Court, and I will never disappoint you. Thank you very much.
It is all these 11 men and women we will decide, but on behalf of all of us, Judge, we wish you success. We wish you all the best in all your endeavors. We are in this journey together, either as a judge of the Court of Appeal or as the Supreme Court. We are joined at the hip to make sure that justice works for the people of Kenya. And we serve the people of Kenya, and we do so faithfully. So with that, you are released. We will get in touch with you when we complete the exercise.
Thank you very much, CJ.
Yes. God bless you. I think there is a stray paper there in that file.